Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity.
Don't let him gloss over this, guys. It clearly said you're supposed to notify all parties, not let one of the parties, like the defense attorney, Brian Steele, discover it through whatever means he had, however he discovered it, and then let's talk about it. No, it said notify all parties. So let's not gloss over that.
To respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams.
All right, so he's making the case for why the court has taken this case from him and another judge is going to be assigned. And I think it's just kind of funny to listen to him explain why the transcript is being provided now, that he wanted to keep a secret. This is all about the whole secret meeting, Fani Willis's office or Fani Willis's team, defense attorneys, prosecution team, Fani Willis's prosecution team, as well as Judge Glanville one of the star witnesses on the trial having this ex parte communication. The judge, he was pissed off about, Brian Steele discovering this had taken place. And now that it's been taken out of his hands, he makes it seem as though he's providing the transcript by his own free will. But we all know that's not the case. He's now being told that he has to do so.
Ms. Novy, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then, do you have an actual or perceived conflict in this case?
No.
Have you been, I'm asking you at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
I did.
Isn't it funny? Isn't it funny that this judge has the nerve to ask this attorney about whether she may or may not have a conflict of interest? Like, isn't this ironic? The irony.
Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up. And what happened in the ex parte proceeding, we're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect. Is on mute?
Yeah, you're good now. Yeah,
with respect to this court. So completely different matter. And now we're dealing with a contempt hearing of Miss Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different. And in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, but all right.
Well, I think half of America has not. I said I think half of America has knowledge of this particular case at this point.
Okay, but they're not before us at this point in time. So what else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchens' case.
All right.
So I'll speak for both of us in that respect since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay. So
since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you show desire.
That's fine. So
I'm telling you at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay. All right. Madam, unless you have anything else, you all can be excused.
Man. So the full transcript of this whole secret meeting and between Judge Ural Glanville and DA Fani Willis's team has literally just been released, guys. So as you guys might remember, this is in connection to the YSL RICO trial. It's been going on for months now. And a lot of critics have called out the prosecution team for allegedly wasting taxpayer money, when they tried to intimidate a key witness. And so it's blowing up in their face now. And the same was said for Judge Ural Glanville, as basically he's also faced a lot of backlash for his actions connected to this case. Now, Glanville, he went nuts when he was told by defense attorney Brian Steele that their secret meeting, is no longer a secret. In fact, he got visibly pissed off. He stood up, started threatening Brian Steele to spend time in jail for not disclosing his source of his information. And so now we have the full transcript. Analysts believe that the judge is, under so much pressure as he's trying to prove to Fulton County that he's not corrupt, right? That he wasn't working together with Fani Willis's team. So to silence these criticisms, he's now been forced to release this closed door meeting. And I just want to go ahead and say right now that it doesn't look as if the judge is being impartial here. Now, especially when you look, especially when you find out what the prosecution was telling key witness Kenneth Copeland. So take a listen here.
The judge presiding over the YSL trial has released a transcript of the controversial secret meeting with a key witness last month.
That meeting happened in Chief Judge Ural Glanville's chambers and caused outrage from defense attorneys. Fox 5's Christine Spiro is at the live desk with the latest on this. Christine?
Courtney and Russ, in that meeting, prosecutors told Kenneth Copeland if he refused to testify, he could be jailed until all the defendants finished their trials. Now, several other attorneys for Copeland say they weren't present in the meeting because they weren't told about it. They have since pushed to have Judge Glanville removed from the case because of this. Copeland was held in contempt on June 7th, the Friday before the secret meeting on June 10th. He was jailed for refusing to answer prosecutors' questions. At the time, Copeland said he would invoke his Fifth Amendment right against self-incrimination. The released transcript also contains an email from one of Copeland's attorneys accusing prosecutors of endangering his client by forcing him to testify. Prosecutors pushed back on that claim. The transcript also stated prosecutor Adrian Love raised concerns about whether Copeland understood the immunity agreement in exchange for his testimony. The judge told Copeland they wanted to give him the chance to ask questions and clear up any confusion before he was brought to testify. Now, in response, Copeland told Judge Glanville, quote, "I have never been truthful a day in my life. I don't comprehend none of this stuff that's going on." The meeting ended with Copeland finally agreeing to testify. Now,
He said he was never truthful a day in his life. That is so funny. But without even reading the transcript, many people they're already saying that Judge Glanville, he planned to conspire with Fani Willis's team, right? There is no angle here that you can look at this where this action can be defended. I'm sorry. I mean, there are critics that are saying that Judge Glanville should be disbarred and possibly even face criminal charges for what he did. Now, what do you guys think about that? Should the judge be disbarred? Should he face criminal charges? If you haven't already, by the way, hit the like button for the video, subscribe to the channel. Really appreciate you guys. But yeah, and the same could be said for the prosecution, since it looks like there was some possible witness intimidation of Mr. Copeland. But what's really frightening is that Copeland admitted that he didn't know what was going on, and yet the prosecution successfully got him to testify. Now, something doesn't make sense here. And even if, even though it kind of looked like they successfully intimidated Copeland, he didn't really give him much, if anything, at all through his testimony. So now basically we also have to remember that DeMonte Kendricks, aka Yacht Gotti, he filed a motion with the Georgia Supreme Court, and according to him, Deputy District Attorney Simon Hilton allegedly told Copeland that he won't be prosecuted. But in order to do that, Copeland would have to lie on the stand. Glanville allegedly also coerced Copeland to testify. So how crazy is it that this is happening in Fulton County, right? All of this stuff is happening in Fulton County, right? Now it kind of really just shows you that DA Fani Willis, basically what she's done to the justice system over there, right? Lying is now part of the strategy to win, it looks like. And so now the Supreme Court, they sent this motion back and basically said that a lower court judge would have to review the motion for removal. And it's now part of it's basically put this entire trial on hold as a result. So this transcript is around like 55, maybe 56 pages long. So, we'll definitely cover just the important parts. So not to waste time. But before we begin, I just kind of want to say that it's going to be incredibly surprising to see if Judge Glanville is not removed from this case permanently. He was there when all of this was said. He's still sticking to his guns that this was a proper ex parte conversation. But let's get back to what the prosecutor Hilton told Copeland, right? So she told Copeland that whatever you think, whatever your truth is your truth, whatever that means, right? She admitted that she's not aware of what the witness planned to say on the stand, but that pleading the fifth was going to keep Copeland in custody. And this is the message that they pretty much made clear to him. It's either he cooperates or they keep him in custody. Now, do any of you guys feel as if this was witness intimidation? I mean, seriously, guys, possibly coercion? Now, if you recall, this is what defense attorney Brian Steele was arguing. And it's what Judge Glanville, it's what pretty much set Judge Glanville off. Like, he went off on Brian Steele, and Steele ended up saying that the prosecution was intimidating a witness and that the judge was there to oversee it. Now, we now know that this is 100% true, even though that this was being denied previously. So Copeland was, let's just say Copeland was trying to recall previous conversations that they had, and the prosecution basically said that he remembers the details wrong. Really? So DA Fani Willis's prosecution team is telling the court that the witness remembers the details wrong. Really? Okay. Now, there's also the lengthy back and forth about immunity, a motion that Copeland never asked for but was given to by the prosecution. So it really seems like the prosecution was definitely trying to make this witness do what they wanted them to do. But the option to plead the fifth was now off the table. He could still do it, but Judge Glanville made it very clear that he would be held in jail until the trial is over. So, I don't know, it kind of seems like more coercion, more steering. And he also said that the only thing keeping Copeland in custody was his refusal to testify. So in other words, look, if you just testify, we'll let you out. And so it's very clear what they wanted him to do. Now, after asking Copeland if he had any questions, he answered by basically saying that he doesn't trust anybody in this meeting and that he didn't know what was going on. Now, this is the second time he said this. They continued this back and forth. There was some bickering about pushing Copeland to testify and that this would keep him out of jail. Now, it even got to a point where Hilton said something absolutely insane, guys. Now, I'm going to go ahead and quote her here because, you know, it's driving me a little bit nuts. Now, this is what she said to Copeland at one point. Quote, "Get this part through your head. If you don't testify, that is the only thing that is holding you. This is literally the only thing holding you right now is the fact that you keep saying, I'm going to testify," end quote. Now, basically, you know, then she went on and said that if he does testify, he can go home. So there was a clear out. There was a clear bait for the witness to do what the prosecution wanted. He could be home with his baby for her birthday, see his dogs deliver their babies, and, you know, be able to talk to his nephews again. So, you know, but do you guys see what's going on here? Like how much pressure they're putting on a key witness? Now, what do you guys think would have happened if the defense team were there with Copeland? I mean, they would probably question the intent of the prosecution and why the judge was, you know, just kind of going along with it, right? So, guys, I mean, I think this reeks of corruption. It's got Fani Willis's office fingerprints all over it. I mean, the prosecution team, they came this short to telling Copeland that it's okay to lie in court, right? And we got a lot more to talk about when it comes to this case, but obviously we're going to have to wait until it resumes. They yanked the case from the judge. So Judge Glanville is basically on vacation, or at least vacation away from this particular YSL Young Thug court case. But the expectation is that at this point, Judge Glanville is gone. So he should not expect to come back to this case. But what do you guys think about this? Like, isn't this kind of crazy? Like, do any of you guys think like this ex parte meeting was proper? Because Glanville at one point definitely thought it was okay. Or was it an underhanded attempt by the prosecution to get what they wanted out of the star witness? Now, you know, a lot of folks are now under the impression that Judge Glanville has never had a fair trial during his entire stay in Fulton County, which kind of reminds me of the coverage of Donald Trump's immunity case and how supporters feel that he's not being treated fairly. Obviously, I did a video about that where I talk about the historic ruling from the Supreme Court and how things are now shaping up for former President Donald Trump. But here's a clue. we could be looking at the next president of the United States. So make sure you guys check that video out. What a tangle web we weave. I feel you, Lurky. What's going on, Keenan Ripon, Fed Up Patriot? What is going on, Zeke Sanchez? Happy 4th of July to everybody. What's going on, Kathy? I see you in the comments. Appreciate the support. Awesome. So, guys, if you haven't already, do hit the like button for the video. I totally appreciate the support. You guys are absolutely amazing. And I look forward to seeing you guys on the next one. Take care.